protocol, of course, the first version was groundbreaking in terms of the idea of standardizing the way that we collect evidence from survivors of torture for the purpose of justice mechanisms. And the 2022 update really delved a little bit more deeply into areas that were not covered as well in the original version, and namely part one of them was sexual violence and sexual torture, and the other part, more specifically, is an evaluation, the evaluation of children. But I think one of the great benefits of the Istanbul Protocol is the ability to structure the way we do these evaluations. And I speak as a physician from the medical legal perspective, this is a skill. It's an acquired skill. Every health professional can acquire this skill. This is not something that's unbelievably difficult, but you do need to be trained in how to do that. And that the reason is that this is very different from a regular physical examination when you document physical and mental health signs for the purpose of a medical diagnosis or for the purpose of treatment. There are differences between these two types of processes and procedures. And, it's not a surprise that health professionals around the world, when they go to medical school or nursing school or other types of school, are not trained in how to collect the evidence in such a way that would help the objectives of the Istanbul Protocol, which include having evidence that is admissible in court for justice mechanisms, among other objectives. When we train health professionals in working with the Istanbul Protocol as the framework, we see that there's more of a standardization in the way that they interview survivors of torture and sexual torture, and that there's a standardization in the way that it's documented and written up. And there's a very, very specific purpose here. It's not that a health professional can say, I saw that survivor of sexual torture and I certify that that person had undergone what they purport to have undergone. The whole notion of the Istanbul Protocol is the corroboration of the clinical findings, be their physical findings, be their mental health findings, and the narrative of the survivor or the patient, depending on the context in which you see them. And so it is a way of bringing the two together and saying that as an expert, as a medical professional, as a health professional, it is your opinion, after years of training, that you can corroborate the consistency of the narrative of the individual with your physical findings. Sexual torture is a particular type of torture that is extremely difficult to talk about. And it's not just by women, it's not just by men, but there are differences along gender lines. There are differences according to where you come from and cultural norms in which you grew up in, and how easy it is to talk about general sexual matters, talk about the anatomy of a male, female, non-binary people. It's even in the regular medical assessment without torture, it's very difficult for a lot of patients to talk about that. And it's also sometimes difficult for clinicians to talk about that, to bring this up, let alone when it's part of the worst day or period of time that somebody has gone through this kind of experience. So there are issues of shame, there are issues of fear, there are issues of stigma, cultural issues, and of course those go both ways. They're all on the part of the survivor and on the part of the clinician who's trying to get this testimony. So part of the standardization is, how do you ask these questions in a way that is least troubling to the individual? Oftentimes I hear people say, well, what about re-traumatization? Maybe we shouldn't do it. That is from my personal view, is that I think, while I 100% agree that re-traumatization is a risk, I think sometimes we use that to avoid going through the process. Oftentimes, in my experience assessing torture survivors, sexual torture survivors, is that oftentimes they do want to tell their story, and there is a therapeutic element to undergoing this evaluation and the documentation. So we train physicians how to do this in a way that is trauma-informed. There's a trauma-informed way of doing the interview. There's a trauma-informed way of doing the physical examination, and then putting this all together in a consistent and standardized approach that uses standardized language to say what it is that they can't say. They can't say this person was raped. You weren't there, you can't say it. But there is a way of saying their scars, their mental health manifestations are consistent or highly consistent with the stories that they allege happened to them. But also, it's about trying to normalize this as much as you can normalize sexual torture. But for example, if you think about a person you're seeing in front of you who may not be disclosing this, but you know that they're in a custodial setting where oftentimes sexual torture occurs, you know, there's a way of asking the question. For example, I know that we hear, or throughout my career, I've heard of many people in your situation who have had experiences involving their genitalia. Did anybody ever touch your genitals in a way that you, that somehow wasn't right in your mind? And so part of the training specifically on sexual torture is training the clinicians on how to ask these very difficult questions. They're never fun to ask. 9 out of 10 times survivors don't want to disclose. And there are all kinds of different techniques of interview techniques. There are physical examination techniques to ask them, and specifically also not assuming that at the end of this visit or at the end of the assessment, that if they didn't disclose, that it didn't happen, and then coming back to it in a way that is as gentle as possible, that is as less stigmatizing as possible.
The purpose of documentation in our situation was to establish the truth, because, as I said, there was a lot of stigma and taboos and prejudice towards this crime, and different narratives were confronted. So we wanted to establish the truth, also support survivors for justice, as well as recognition of survivors by law, by one state mechanism. Documentation, it came later, after 20 years of existence as an organization. We already are working constantly on providing holistic rehabilitation to survivors. Documentation is a voluntary process. Each and everyone who is part of the documentation, they have gone through the psychosocial or medical support. But also process of the documentation is an empowerment process, and it's a precondition that survivors without having at least 6 months treatment cannot enter in a documentation, because we are reopening the trauma event. So there is a precondition by the protocol. And I would like also to share our manual, which is clearly defined each stages how we do the documentation. But documentation is a parallel process, and it's a voluntary process for those who would like to share the story. So it's just to contribute to the truth and to advance their rights, to amplify the voices, but it's not the first intervention we do to the survivors. Each and every policies and process are established in KRCT, but also policies and laws that we are aiming to change, they are based on the needs and requests survivors bring in the organization. The voice and requests of survivors are making the philosophy of organization.
Most of the survivors of sexual torture who have spoken publicly, they didn't speak because they were in Somalia. They only spoke publicly when they left Somalia. Otherwise, they dare not to speak publicly inside Somalia, because they know the consequences is really loss of life, facing reprisal that amounts to targeted killing and other enforced disappearances, and also kidnappings, because also there's a stigma, especially both for men and women, but for men it's even more catastrophic stigma if a man is raped. But some men have done it, but they were not inside Somalia. and they were able to talk about their harrowing history and painful experiences they gone through, as well as also some other courageous women also did speak out publicly. And that was absolutely one of our main work to encourage if they can, because one voice that comes out is an alarming voice for the public, and that can absolutely lead to a change, to a policy change, to legal change, to other changes.
I think consent is consent as long as you do a good job going through the process of explaining what the risks are. Maybe the risks of disclosure of sexual torture are a little different because of the heavy cultural associations and shame and stigma. So if, but if a person does not give you consent, that's the end of it, and you have to respect that. So I think I don't see a different, we don't have different forms for sexual torture versus any other torture. But it's also important, and we do this in PHR training, is to train clinicians how to obtain consent in a trauma-informed manner. What are the things that you need to involve? Again, this is all standardized again, so to make sure that you cover everything and you really describe to the survivor the potential for harm for themselves if this information comes out.
I think that, you know, the flip side of this is also that one thing we do see quite a lot of is also this kind of presumption that you can coerce or force, or you should be coercing or forcing a survivor to go through a forensic examination. I think there's often a drive for accountability in certain contexts. So for example, in a context like Ukraine, where there is a big commitment to accountability by the government, I think there's often, I think, a feeling that, okay, if a judge has told me as a physician I need to do a forensic examination, that I then need to push the survivor to actually consent to the forensic examination. You see that a process that could be potentially healing, you know, ends up kind of turning into something that is harmful when there is a presumption that actually a survivor needs to be coerced, you know, to go through with this exam, in part because a clinician may also feel that the judge is directing them to intervene. And this is part of the reason that we often think about how, you know, building good practices and documentation of sexual torture requires more than just training clinicians, although training clinicians is obviously a critical aspect. It also requires training these other sectors. And so that's been a big part of our project now, is then engaging with the Supreme Judicial Council and really thinking about how we can support a shared set of terminology, a shared set of language and understanding of each other's roles, and also really an understanding of the myths and misconceptions that can undermine the collection of comprehensive evidence and evidence that's collected in a way that is survivor-centered and trauma-informed. There are a number of myths and misconceptions around documentation of sexual torture that I think the Istanbul Protocol really well lays out. And I think it's very important when we think about capacity building and training around doing documentation, that we think about how we can use the moment, not just to teach a clinician how to walk through the different steps, but also to how to think through some of these myths and misconceptions which may undermine the ability to document evidence well and in a way that isn't re-traumatizing. And so some of these really include this idea of being able to test virginity, or this idea that if somebody is not a virgin, that they could not be subject to rape. There's, you know, the IP is really clear that forced hymen examinations to detect virginity and forced anal examinations of individuals to detect same-sex activity are examples of clinical examinations that have no clinical value, that represent forms of sexual assault and constitute ill treatment themselves and may amount to torture depending on the individual circumstances. There's also myths and misconceptions that come up around the idea that children can't be trusted or women can't be trusted, that if there's inconsistencies in a story, that it means actually that the rape didn't happen or sexual torture didn't happen, when actually this can be a product of trauma as well. And so this is another area where I think the Istanbul Protocol is quite clear about these areas, these norms that really do undermine documentation, but are very important to be aware of. Beyond that, the Istanbul Protocol also specifically calls out the fact that many clinicians, and I think actually many judges, and I'm a lawyer, so I can critique the legal profession. I think many lawyers, they have this understanding that if there's no physical injuries, that means that no violence happened, no sexual torture happened. And yet, actually, again, as the clinicians on this call could tell you, a lot of sexual torture does not actually result in physical injuries specifically to the genital area. And by the time a survivor comes forward, those injuries may also have healed to the extent that they even existed. And so this is why it's both really important to do a full head to toe examination, because injuries may actually be elsewhere on the body, but also to do an examination that looks at the longer term impacts, including psychological evidence, as well as evidence of longer term health harm that can arise from sexual torture, including issues around urination, pregnancy, obviously, then STIs, fistulas, pain, sexual dysfunction, including fear of intimacy and other sort of hesitation around engaging in sexual activity or reproduction, the mental health impacts, including depression or self-harm. And then we also see this myth that if an exam has to happen within 72 hours, and it's something actually we hear quite a lot, especially in conflict contexts, where there is a feeling that if the examination hasn't happened within 72 hours, it's not worth doing an examination at all. And I think this, again, goes to that point of we need to actually understand that there's a lot of evidence that can be gathered around understanding if somebody has experienced sexual torture that can be useful and important for corroboration of a testimony, but it is not just that physical evidence. And then the second piece is that there tends to be an over focus on DNA evidence, which, DNA evidence can be important, but actually it is really not the most dispositive or only form of evidence. And actually in conflict contexts or in context of sort of mass atrocities, actually we're not always also legally looking at the DNA evidence as the most important evidence, because we're not trying to link just to a perpetrator. We're actually thinking about the command responsibility, who was actually in charge of that group. And so it's actually things like the insignia on a uniform, the language being spoken by the perpetrator is equally, if not more, actually more important, because the DNA evidence is really about that individual perpetrator. But I think the Istanbul Protocol is actually quite comprehensive in thinking through some of these different ways in which documentation can be hindered, but it's not just the clinicians that need to learn this or be aware of this. It's actually, again, prosecutors, it's judges, and even looking outside of the criminal justice context, it's important for health systems in designing reparations and designing these medical interventions to support survivors to be able to understand the full breadth of harm.